Abhinav sir, am I audible to you now?
Yes, I can hear you, Nishika.
Thank you, sir. Sir, we'll start with the session now.
Yeah.
Good evening. A very warm greeting to each and every one of you. I, Nishka Srinivas Veluwali, your host, welcomes you all in this live session organized by Law Insider, the media publication house known for its captivating articles, legal news, columns, and even for organizing webinars on topics in legal frontiers. Today, we have taken this opportunity of organizing a special event to commemorate the Golden Jubilee year of the landmark judgment in the realm of Indian Constitution, the Kesavananda Bharati case. In this session, we will be revisiting the concept of the basic structure doctrine of the Indian Constitution. This doctrine was propounded by the Honorable Supreme Court of India on 24th April 1973 in the landmark case of Kesavananda Bharati versus the state of Kerala. The court here had held that the amending power of the constitution cannot be exercised in a manner that it destroys or weakens the basic or fundamental features. This doctrine has been a subject of discourse and debate for last 5 decades on the concerns whether it poses a counter majoritarian difficulty. In this session, we will delve into the horizons of the doctrine and try to understand its implications for the Indian Constitution and the Indian polity. Now, I would take the great pleasure of welcoming our today's guest of honor, Professor Abhinav K. Shukla. To briefly introduce, Abhinav Sir is the graduate from Hidayatullah National Law University with an honors in constitutional governance and corporate laws. He did his master's from OP Zindal Global University in constitutional laws and also bagged a distinction in GST laws. He has been mentoring the CLAT aspirants since 2015. He has worked as faculty, mentor, and national anchor with leading CLAT preparation institutions. He writes columns and articles for national newspapers such as Hindustan Times, the Daily Guardian, the Pioneer New Delhi, the Hitavada. Presently, Sir is associated with the Hidayatullah National Law University, Raipur, as an assistant professor of law. Sir, a very good evening. It's very overwhelming to have you with us on this platform. Shall we proceed towards the questions, sir?
Thank you, Nishka, for the warm welcome. Yes, eagerly waiting to begin the discussion.
So, before proceeding more into the depth, can you please give us a background or a brief introduction of what basic structure doctrine is?
We are here today discussing, celebrating the 50 years of the Kesavananda Bharati verdict delivered on 24th of April 1973. The basic structure doctrine, which was propounded 50 years ago, is not one of those judgments or case laws which is about deciding the dispute or adjudicating on a present matter. It's not only about giving a doctrine which is applicable on a specific set of issues and aspects, but this is something which was relevant in 1973, which is equally relevant today in 2023, and which is likely to remain, the same in years and decades to come. Briefly talking about the doctrine, as the word states, as the name states, the basic structure, the fundamental principles of the Constitution. The major aim of propounding this doctrine, the intention of the Supreme Court was to specify, to classify certain features of the Indian Constitution as the basic pillars, as the fundamental principles of the Constitution, which are unamendable, which cannot be amended by the Parliament despite having absolute majority. And the purpose behind is that the Constitution of India was drafted by the Constituent Assembly based on certain principles, socio-economic factors, and the history of India. So, keeping all these things in mind, the Supreme Court propounded this doctrine in which certain features were given not as an explicit list, but in an inclusive manner, which can be amended from time and again, and things can be added into the list as and when required. It can be said that the doctrine has not only survived over the last 50 years or 5 decades, but has in fact become an instrument of interpretation of the Indian Constitution. Therefore, it is really significant to discuss about the doctrine, how it got evolved, its reaffirmation, and how it has changed the course of Indian constitutional law, its interpretation, and the most important aspect is how it has brought impact on the Indian democracy.
That's really very informative, sir. Now, there's one more question that's been going around, that how exactly did this basic structure doctrine evolve in India? What is the background of such a landmark case that is known as Kesavananda Bharati case? So, if you could please enlighten us upon that.
Indeed, as you said that, this is one such question, one such doctrine. And in fact, in the introduction, you mentioned that this has been a matter of public discourse right from 1973. And in fact, in 2023, when we very often witness, the members of the judiciary and the executive exchanging words in that time-seated arguments in favor or in against the basic such doctrine. So it's important for us to go back and to look into what were the situations at that point of time that this doctrine had to be evolved or had to be propounded. The Constitution of India is a very significant document because of the fact that India is a constitutional democracy, which means the executive, the legislature, the judiciary, and each and every one of us are governed by the Constitution of India, its principles, and the rules, regulation, the authorities, powers, duties, and functions which are laid down by the Constitution of India. In 1950, when the Constituent Assembly had enacted and had implemented the Constitution of India, when we got it in the form of a document from 26 January 1950 onwards, we had certain specific provisions in the Constitution which were specifically made and inserted in the Constitution to make sure that the Indian Constitution is a living document, which means it can, adapt the things as per the changes in the society, as per the socio-economic changes, as per the requirement of the society and the nation. And for this very reason, Article 368 was inserted in the Constitution of India by the Constituent Assembly to provide amending powers to the Parliament of India, which means using the powers provided to it under Article 368, it can amend the provisions, the parts of the Constitution of India. But to keep this in mind, before we move ahead with the discussion on the cases and the background, it's very significant to note down over here that Dr. B.R. Ambedkar, the chairman of the drafting committee, he discussed this in the Constituent Assembly, that what is the difference between the power of the Constituent Assembly and the power of the Parliament. Why is it so that the Constituent Assembly was required to pass an amendment or a law or a resolution only by a simple majority of 50%, but the Parliament under Article 368 is required to attain minimum of a 2/3 majority of both the houses of Parliament, that is Lok Sabha and Rajya Sabha, which is also known as special majority. Why this differentiation? Because it's also a very common perception that whenever the parliament amends the constitution using its power under Article 368, it is using its constituent power, which was the case with Constituent Assembly as well. So Dr. B.R. Ambedkar specifically highlighted an issue and said that while we are sitting over here as the Constituent Assembly, we do not have any political motives attached. The Constituent Assembly was made for a specific purpose to draft the Constitution of India. And from now onwards, from 1950 onwards, the Parliament of India is going to take, the responsibility and the authority to pass the laws, amend the Constitution, etc. While the Constituent Assembly did not had any hidden political motives or other motives, in pure language, in a very plain language, what we may call as vote bank politics, etc. The Constituent Assembly is not sitting over here with such, motives and intentions and agendas. So while we as Constituent Assembly are drafting and making the Constitution, our intentions and motives are completely different, which would not be the case, certainly not the case with the Parliament of India, which means the Parliament of India would be composed of, certain political compositions consisting of several political parties who are elected to power, will be elected to power through general elections and direct elections, indirect elections. Then based on that, the composition, the majority, they'll be able to form the government, etc. So therefore, he said that it's very important and significant to allow the Parliament to amend the Constitution only with a special majority, that is 2/3 majority. And this, we will get back to this particular aspect when we, at a later stage, we'll be discussing about the prospects of the basic structure doctrine, the present and the future prospects. Keeping this in mind, the Constituent Assembly empowered the Parliament of India to amend the Constitution under Article 368, of course, with the 2/3 majority provision from both the houses of the Parliament. Now, in this regard, the Parliament in 1951 onwards started amending the Constitution, and in 1951 we had the very first Constitutional Amendment Act of 1951. What was the reason why this amendment was brought? To briefly talk about this, the government of India started with a lot of initiatives, development works, socio-economic developments across the nation, 1950 onwards, which required a lot of land acquisitions, which means acquiring the lands of, the zamindars, the people across the nation, to use those lands for the construction of public utility space, infrastructure, hospitals, etc., for which the government had to acquire certain lands for the construction of railways networks, etc. And at that point of time, the Constitution of India had Article 19, Clause F, which was the right to property as a fundamental right in the Constitution of India. So whenever the government had was trying to acquire the lands of the people through the Land Acquisition Act, the plethora of cases were brought to the Supreme Court and the High Courts in terms of writ petitions that this step of the government, this act of the government, is a violation of our fundamental right. And there were various such challenges. The Parliament introduced the First Amendment Act in the Constitution in 1951, inserting the 9th schedule in the Constitution. Initially, the Constitution had only 8 schedules. So the 9th schedule was inserted with the purpose that if any law, any legislation is inserted in the 9th schedule, it would be exempted from judicial review, which means we can pass a Land Acquisition Act under which would be put under the 9th schedule and which would automatically become exempted from the judicial review, which would, make it an easy path for the government to acquire the land and go ahead with its development work and, to match up the DPSP, the Directive Principles of State Policy in terms of the welfare state and the concept of socialist or socialism. The first case in this regard was the case of Shankari Prasad versus Union of India, which was filed in the year 1951, right after the first Constitutional Amendment Act, in which the first Constitutional Amendment Act was challenged. And it was challenged on the basis that the ninth schedule, which has been introduced to the first Constitutional Amendment Act, is violating our fundamental rights. That is right to property under Article 19, Clause F. And what was the basis of this challenge? The basis was Article 13, Clause 2 of the Indian Constitution. Article 13, Clause 2 says that the state shall not abridge the fundamental rights of the people. Abridge how? The state shall not make any law which shall abridge the fundamental rights of the people. The challenge, the fundamental question, the constitutional question, the matter of interpretation in this case was that whether a constitutional amendment act which the parliament passes under Article 368, because the name says Constitutional Amendment Act, and that's how the other acts are also known as. The Right to Information Act, the Competition Act, all of these are acts, a legislature. So the question was whether a Constitutional Amendment Act passed under Article 368 is also a law, is also an act, and is to be treated in the similar manner as we treat the other laws and legislations. Because if that is the case, if we have to treat a Constitutional Amendment Act as a legislation, as an ordinary legislation, then it would come under the purview of Article 13, Clause 2. And 13, Clause 2 restricts the Parliament from making any law which abridges the fundamental right. So, for the first time in the Supreme Court, in the case of Shankari Prasad versus Union of India, a constitution bench of 5 judges, the matter went for this interpretation. The Supreme Court, with a majority of, in fact, it was a unanimous judgment, wherein all the 5 judges said that the power of the Parliament to amend the Constitution under Article 368 is to be considered as a constituent power and not as an ordinary legislative power of the Parliament. Because for passing an ordinary legislation, you need a simple majority. For passing a Constitutional Amendment Act, you need a special majority of 2/3. And therefore, there is a distinction between the ordinary legislative power of the Parliament and the constituent power of the Parliament. And in this regard, the Supreme Court stated that any Constitutional Amendment Act passed by the Parliament under Article 368 would not be considered as a part of Article 13, Clause 2, which means it is not to be considered as an ordinary legislation. The Supreme Court cleared the way, paved the way for the government to go ahead with its development work or etc. And the 9th schedule was held as valid. For the second time, because this was of course not the final stop in this regard, this was just the beginning. The next matter in this regard had come up to the Supreme Court in 1965 in the name of the case Sajjan Singh versus State of Rajasthan. In this case, the 17th Constitutional Amendment Act of the Constitution, it was challenged. And it was challenged on similar grounds in terms of whether a Constitutional Amendment Act can abridge the fundamental rights or not. Because it was still impacting the fundamental rights of the people, and specifically through the right to property as a center of discussion or center of dispute or conflict. In this case, the majority of the bench, it was again a constitution bench judgment given by 5 judges. And in this case also the majority, that is the 3 judges, the then Chief Justice and the other 2 judges, they gave the similar opinion as was given in the case of Shankari Prasad, stating that no Constitutional Amendment Act is not a part of Article 13, Clause 2. It's not an ordinary legislation, and hence we have to treat it differently. And therefore, a Constitutional Amendment Act cannot abridge the fundamental rights. As in, it is not to be treated as a law. And even if it is doing so, it is not going to be struck down under Article 13, Clause 2 by the court. But interestingly, in this case, there was a minority opinion, a dissent given by 2 judges, Justice Mudolkar and Justice Hidayatullah, who had objected to this particular aspect of that whether Parliament should be given uncontrolled power to amend anything and everything in the Constitution. Can we do so? And in that particular regard, in this particular case, in the dissent opinion, the first aspect with respect to certain basic features had come into the discourse, wherein the minority had given an indication with respect to establishing certain basic features or restricting certain basic features which should not be allowed by the parliament to amend. Moving on to the next case, 1967, IC Golaknath versus State of Punjab. The first and 17, both the Constitutional Amendment Acts were again challenged in the case. And this time we had 11 judges, a constitution bench of 11 judges, to revisit the same question, which was given, in the previous two cases of Shankari Prasad insurgency. And this judgment is considered to be one of the, matters of highest judicial creativity, because in this case, it was for the first time that the Supreme Court stated, and the Supreme Court had established an absolute obstruction in the power of the parliament. The majority of 6 judges in this case said that the parliament cannot amend part 3, that is fundamental rights, even using Article 368. And it said that Article 368, the Constitutional Amendment Act, is to be considered as a part of Article 13, Clause 2, and is to be treated in a similar manner. And this was considered, as a major turning point, because now it had become very problematic for the parliament, for the government, because now the Supreme Court said that you, as the parliament, although you are the elected majority, you have the people's mandate, but still you cannot amend the fundamental rights. Why? Because of the obvious reason that 368 Constitutional Amendment Act also forms a part of 13 Clause 2. And this had become a matter of great concern for the government, because yes, of course, one thing to be mentioned over here, that the Supreme Court was also considerate enough to propound another doctrine, a doctrine in this case known as the doctrine of prospective overruling, which means that we are giving this judgment and we are saying that parliament is not authorized to amend part 3, that is fundamental rights, but it would be considered in a manner of a prospective overruling, that is, this would apply from now onwards and not retrospectively, which means all the things which have been done by the government in last 17 years need not to be undone, because it would have become a matter of great concern, and it would have situated great chaos. Of course, things which have been done in 17 years, that too in such a massive scale, cannot be undone. So the doctrine of prospective overruling was propounded. And then we had this Golaknath judgment. But how Parliament could have taken this so easily? Of course not. And in fact, this was also considered as one of the highly criticized judgment, because of the fact that on one particular end, it restricted the parliament from touching part 3 or amending part 3. But at the same point of time, it also did not speak anything about what about the other parts of the constitution, what about the preamble, what about the democratic feature of the constitution, what about the federal structure of the constitution, nothing. Which means it said you cannot touch part 3, you cannot amend part 3, but it did not give any clarity in terms of the other parts. And in fact, as the Constituent Assembly was also of the view that Constitution is a living document. If the Parliament completely restricts the Parliament, if the Supreme Court completely restricts the Parliament from amending Part 3, it would have become completely, rigid, and it would not have the scope. There would have been no scope of amending the Constitution as per the needs and requirements of the society. For example, we now have Article 15 Clause 6 for the EWS reservation. We have Article 21A as right to education, new additions in the Part 3. These would not have been possible probably because of the Golaknath judgment in place. To overcome the effects of the restrictions imposed by the sanctions imposed by the Supreme Court, in this case, the Parliament had come up with the 24th Constitutional Amendment Act in 1971, introducing 2 amendments in Article 13 and Article 368 respectively. In Article 13, it inserted Article 13, Clause 4, which stated that nothing in Article 13 shall apply to 368, and in 368 it inserted Article 368 Clause 3 stating that nothing in 368 will apply to Article 13, which means exactly what was said by the Supreme Court in terms of interpretation of relation of 368 and 313. And it said that Article 368 comes in the purview of Article 13 Clause 2. The Supreme Court the Parliament to overrule this, to overcome with this restriction or sanction, it removed this sanction by the introduction of the 24th Constitutional Amendment Act, which means again allowing the Parliament to amend anything in the Constitution, including Part 3, that is fundamental rights. And then there were other amendments in the Constitution. 25th Constitutional Amendment Act and 29th Constitutional Amendment Act. 29th Constitutional Amendment Act was specifically with reference to the Kesavananda Bharati. Who was he? He was the head, he was the Matadish of one of the mutts in Kerela. And the issue was with respect to the Kerala Land Reforms Act of 1970, as per which the land of that particular mutt was to be acquired by the government of Kerala, by the state of Kerala. And that particular Kerala Land Reforms Act 1970 was inserted in the 9th schedule of the Constitution to exempt it from judicial review. And therefore, a writ petition under Article 32 was filed by Kesavananda Bharati in 1972, March 1972, and the hearings for which began in October 1972. The hearings went on for about 68 days of hearing till 24th April 1973, and we then got this verdict on 24th April 1973, in which the highest ever 13 judges bench of the Constitution. It is important to note that at that point of time, we had only 15 judges in the Constitution. The full strength was of 15 judges, and out of which 13 judges were sitting for a judge. Just imagine, today we have the strength today is 34. Out of 34, 30 judges, maybe not that relevant, but just talking about the ratio. So out of 15 judges at that point of time, 13 judges sitting, to review the Golaknath judgment and the position, and of course, the 24th, 25th, and 29th Constitutional Amendment Acts. And why 13? Because Golaknath was 11, so to reconsider it, there had to be a larger bench. So in this particular case, it had come up with a decision of 7:6 out of 13, in which this doctrine, the basic structure doctrine, was propounded. Something which was indicated in the case of, in the dissent opinion of, Sajjan Singh, the second case. That is, the Constitution of India has certain basic pillars, basic features, which can never be amended by the Parliament, even if it is having absolute majority, even if it attains the 2/3 majority using its power under Article 268. It can amend anything in the Constitution, including Part 3, including all the portions, but not the basic features. So just to briefly look into what things were said by the Supreme Court in Kesavananda Bharati. First, it outrightly overruled the Golaknath verdict. That is, Golaknath said Parliament cannot amend Part 3. It said it can amend Part 3, it can amend preamble, it can amend the Constitution, anything and everything. You cannot restrict the Parliament from amending a specific part, but then this particular amendment power is not unrestricted in nature. This is not unrestricted. There has to be certain limitations, and these limitations will work in the form of the basic structure, which means every time a Constitutional Amendment Act is challenged for its constitutionality, the Supreme Court will analyze whether this Amendment Act violates any basic structure, basic feature, basic pillar of the Constitution or not. The purpose, the idea was, basic pillar, the word means that the Constitution stands on certain, important features, and if certain pillars are removed, then the Constitution, the very purpose of the Constitution is likely to fail, and the very purpose, motive, larger objective of the Constitution is likely to fail. And therefore, this doctrine was propounded way back in 1973, that is the 24th of April, 1973.
That's really very insightful, sir. So exactly when and how was this basic structure doctrine was reaffirmed?
Now, this is very important and significant because in the history of India, of Indian constitutional law, the Supreme Court, the judgments, we have seen various landmark judgments being delivered, maybe overruled by certain acts of the parliament, or overruled by a larger bench. But Kesavananda Bharati, the basic structure doctrine, is one such doctrine, which has been termed, by certain jurists like Upendra Bakshi, that is, the doctrine of basic structure is a very, very strong and dedicated doctrine. And they gave a term to it known as it's a die-hard doctrine, which means it's a doctrine which is not so easily amenable. And that's why we need to know the reasons why it is not so easily amenable, and why and how it was reaffirmed, and why it stands strong even today after 50 years of the verdict. Right after the verdict was delivered on 24th April 1973, there were certain developments in which the judges who were in the minority, who were in the majority, that is, who gave the unfavorable decision, unfavorable in terms of not favorable to the parliament, they were not, the deserving judge was not made the Chief Justice, and they were superseded, and a junior judge was made the Chief Justice of India then in 1973. In fact, immediately after the verdict, a new bench of 13 judges was formed to revisit the Kesavananda Bharati verdict, to revisit the basic structure doctrine, and the purpose and intention was clear enough to overrule the basic structure doctrine. But the co-judges, the other judges of the bench, they did not show much interest, or they did not show the cooperation in terms of this motive or intention of changing or amending the basic structure doctrine. And then in 1975, India saw a major democratic constitutional development, that is the emergency. And the reason for this national emergency imposed in 1975 was the basic structure doctrine. India saw the emergency of 1975. The reason behind it was that because there was a basic structure doctrine in place, the emergency was imposed. Why so? And when we talk about the reaffirmation of the basic structure doctrine, the basic structure doctrine was for the first time used in the case of Indira Gandhi versus Rajnarayan, 1975, in the Supreme Court of India. So, the Allahabad High Court gave its verdict stating that the then Prime Minister and the elections involved in that particular regard, the elections were declared as null and void. And, the matter was, an appeal was filed in the Supreme Court. And while the appeal was pending in the Supreme Court, the Parliament introduced the 39th Constitutional Amendment Act, which had brought a specific restriction on the Indian Constitution, stating that the elections of the President of India, the Vice President, the Prime Minister, and the Speaker of Lok Sabha, these four constitutional authorities, their elections cannot be challenged in any court of law in India, because the elections of the then Prime Minister was challenged in the court of law. So to restrict this particular aspect, before the Supreme Court could hear the appeal against the Allahabad High Court's verdict, this 39th Constitutional Amendment Act was brought. Since it was a Constitutional Amendment Act, and because by that time we already had the basic structure doctrine, this 39th Constitutional Amendment Act had to go through the lens of, the basic structure doctrine, whether it is violating the basic structure or not. On day one of the hearing of Indira Gandhi versus Rajnarayan's judgment verdict in the Supreme Court, the then petitioner, the then counsel for the petitioner, stated that, Your Lordships, there is no matter in hearing this verdict because we already have the 39th Constitutional Amendment Act in place, which states that the elections of the Prime Minister and the other constitutional authorities cannot be challenged in any court of law, which means there is no point in hearing this case. The Supreme Court said that no, we will rather analyze the validity of the 39th Constitutional Amendment Act because we already have a doctrine in place. And therefore, for the first time, the basic structure doctrine was applied. The Supreme Court said that free and fair elections are a part of the basic structure, and Therefore, we struck down the 39th Constitutional Amendment Act was completely struck down by the Supreme Court, stating that be it the President, Prime Minister, Vice President, Speaker, Chief Minister, anyone in India, nobody's election can be exempted from judicial review because free and fair elections are a part of the basic structure doctrine. Well, the basic structure. This was the first reaffirmation. And as an aftermath, although those were the political developments, we're not going on to those. But because this doctrine was in place, and the then Prime Minister, because of these constitutional developments, could not secure the positions, and then it had become one of the hidden reasons for imposition of the emergency. The second reaffirmation of this doctrine was in the case of Minerva Mills versus Union of India 1980, wherein another attempt was made by the Parliament through the 42nd Constitutional Amendment Act to overrule the basic structure doctrine. How? Article 368, Clause 4 and Clause 5 were added in the Constitution through the 42nd Constitutional Amendment Act. And if we read the lines, the wordings of Article 368, Clause 4 and 5, it specifically states that nothing in this Constitution can stop the Parliament, from amending the Constitution. And the Constitutional Amendment Act passed by the Parliament will be exempted from judicial review. These were the, we can still find these two clauses mentioned in our provisions, although struck down and are completely inoperative, ineffective, but still. So this particular part of the 42nd Constitutional Amendment Act, that is Article 368, Clause 4 and 5, were challenged in the Supreme Court in the case of Minerva Mills. The Supreme Court again invoked the basic structure doctrine and reaffirmed that this time it said that, if you remember, I mentioned in Indira Gandhi versus Rajan, it said free and fair elections are a part of the basic structure doctrine. In Minerva Mills, the court said judicial review is a part of the basic structure doctrine, is part of the basic structure. And therefore, if we exempt, if we say that the Constitutional Amendment Act cannot be the subject of judicial review, or the Parliament is having unrestricted power to amend the Constitution, this would go against the very principle of judicial review, and judicial review is a part of the basic structure. The Kesavananda Bharati reaffirmed, and the basic structure doctrine invoked again in 1980. Then immediately after it, in 1981, in the case of Vaman Rao versus Union of India, it was with respect to the 9th schedule, and the Supreme Court clarified that any additions made to the 9th schedule after 24th April 1973, that is the date of Kesavananda Bharati verdict, any additions made to 9th schedule would be subject to judicial review. Another reaffirmation of the case of the basic structure doctrine. Then further, there are many, but we are focusing into the major spotlights. In L. Chandrakumar versus Union of India 1997, it was with respect to the constitutionality of the tribunals in India. In one of the previous lectures, we have discussed this in detail about the constitutionality of the tribunals in India. So, through constitutional amendment acts, the Parliament had inserted the provisions to establish tribunals in India. And we do have tribunals in India right now. For example, National Company Law Appellate Tribunal, National Company Law Tribunals, the Competition Commission of India, these are all tribunals in place. So what happened is, the tribunals, the appellate tribunals, some of them, they were taking away the jurisdiction of the high courts, because high courts are the first, appellate authorities. When it goes, the matter goes in the hierarchy and then to the Supreme Court. So there were certain tribunals established in such a manner that the matter would go to the appellate tribunal and then directly to the Supreme Court, skipping the high court's jurisdiction. And then it was challenged, the constitutionality was challenged in the Supreme Court in L. Chandrakumar, in which the Supreme Court said that the jurisdiction of the High Court under Article 226, the writ jurisdiction, and the jurisdiction of the Supreme Court under Article 32, these are part of the basic structure and can never be, taken away, can never be altered. It although allowed, it said that yes, tribunals, the appellate tribunals are constitutional, they are valid, we can have appellate tribunals, but 226 and 32, you cannot take away these powers from High Court and Supreme Court, which means at any point of time against the decision of any appellate tribunal, people can go to the High Court and Supreme Court under their respective writ jurisdiction. This was another aspect. Looking into the last two recent reaffirmations and application of the basic structure doctrine, one in 2007 and the other in 2015. 2007, in the case of I.R. Koilu versus State of Tamil Nadu, it was again with respect to the basics, it was with respect to the 9th schedule, in which the Supreme Court said that, the government, the parliament, using the 9th schedule as a shield against judicial review of certain laws which violate the fundamental rights is not allowed, and any law, irrespective of the fact that it is a part of 9th schedule or not, would be subject to judicial review, would be struck down or can be struck down if it violates the fundamental right. Just to give an example, the recent ongoing issue with respect to the reservation bill, which has been passed by the Legislative Assembly of the state of Chhattisgarh, although recently the governor has sent the bill back to the state legislative assembly, the government wanted, or it said that once we get the assent, from the governor, we will request the central government, the parliament, to include this particular law to provide, 76% reservation in the state in the 9th schedule, so that we are safe and secure, so that the law is safe and secure. But I.R. Koilu said this particular specific aspect and clarified that the government cannot use the 9th schedule as a shield to protect those laws which violate the fundamental rights. Another important aspect which is still relevant, as I gave a recent example, to get the context. And then the last reaffirmation, not the last or the least, I would say, but in the recent aspects. In 2015, the very well-known decision of the NJAC, National Judicial Appointments Commission, Supreme Court of Advocates on Record Association, Supreme Court Advocates on Record Association versus Union of India. The Supreme Court, by the majority of 4:1, said that National Judicial Appointments Commission, NJAC, and the 99th Constitutional Amendment Act are unconstitutional because they are disturbing the independence of the judiciary, and independence of the judiciary is a part of the basic structure. So these are certain, relevant examples of how the doctrine has not only survived, but has grown. And as said earlier, this doctrine has become instrument of constitutional interpretation in the most widest possible manner or sense.
Sir, how has been this basic structure doctrine impacting the India's democracy, or what has been its role in the democracy of India?
While we were discussing, the reaffirmation of the doctrine in so many cases, right from 1975 till the date, the basic structure doctrine has played a very significant role in shaping the democracy, or often used in a general terms as saving the democracy, or why? Because before the basic structure doctrine and even after that, if we look into the developments, the recent developments of exchange or dialogues between the executive and the judiciary in terms of the correctness of the basic structure doctrine, the vagueness of the basic structure doctrine, or the basic structure doctrine becoming counter majoritarian problem, which means the basic structure doctrine is used as a tool by the judiciary to counter the efforts and the actions of the government. And the government is a authority, is a body which is having full mandate of the people. It's an electorally elected government in place, etc. In this regard, the basic structure doctrine, in 1973, was actually a result of the struggle of supremacy between the executive and the judiciary. Because see, basic structure doctrine did not establish the supremacy of the judiciary, but it established the supremacy of the Constitution of India, but then through the judiciary, which means establishing the supremacy of the judiciary and giving it a power to counter the actions of the government. What kind of actions? We saw the examples. We saw, the attempts made to amend the Constitution for certain personal political purposes. In fact, if we look into the National Judicial Appointments Commission decision, it has, it has been praised by the jurists, but at the same point of time, it is also one of the highly criticized judgments. And we often hear things like collegium system may not be the best system, but it's at least kind of a necessary evil, etc. A lot of such statements. So basic structure doctrine has certainly played a significant role in the Indian constitutional interpretation and democracy, because as said in the beginning, that India is a constitutional democracy, and each and every offices, authorities, everybody functions as per the constitution. So the parliament allows, the constitution allows the parliament that if you have the majority, you can amend the constitution as per your political motives, your idea of constitution, your idea of socialist state or welfare state or capitalist state, whatever it may be, or your manifesto, etc. You may do anything, but you cannot cross the line of basic features, basic structure. And if you do so, the Supreme Court, the basic structure doctrine would be in line, would be in place, sitting over there to undo what the government is trying to do. And we have seen the examples, of so many constitutional amendment acts being struck down by the Supreme Court because of the fact that they are not in line with the larger objective, the constitution, or intention and motive of the constitution itself.
So then, as we all know, there are always two sides of a coin. So what are the problems or the prospects that might be concerning the basic structure doctrine?
We often use a statement for the Supreme Court, which we can also use for the basic structure doctrine, which we may call synonymous, in terms of the power, the tool. Supreme but not infallible, which means supreme, required, but not to be considered as the one which cannot make errors, which cannot, be always right, etc., etc. As said that in NJAC verdict, it has been one of the highly criticized judgments, because there are problems with the basic structure doctrine. And the problem is not outside the bench or outside, the verdict, etc. The problems started very well right from the verdict, right from the decision, right from the bench itself. The bench, as said, was that the judgment was delivered in the majority of 7:6. But there were 6 judges on one side, 6 judges on the other side. But for the majority note, as prepared by the then Chief Justice, Justice S.M. Sikri, the majority note stated this particular doctrine and said, and this doctrine was propounded. The majority note, the 6 majority judges, they stated that there are certain implied limitations in the Indian Constitution which imposes certain implied limitations or restrictions or sanctions on the parliament. This was the view of those 6 judges who were a part of the majority. The 7th judge, who was part of the majority, Justice H.R. Khanna, he did not agree to the majority, and he said that there are no implied limitations in the constitution which restricts the power of the parliament. If we go by the pure reading and text of the constitution and Article 368, it provides absolute power to the parliament to amend the constitution. But then he also said that, but it does not mean that we can give unlimited, unrestricted powers to the parliament to amend the constitution, and therefore the basic structure doctrine is propounded and so on. But there were many such things which lacked clarity. There are many such things with respect to the definition, the features, the usage, the scope, etc., which have been termed as vague. And it is also said that this is one such doctrine which can be used and which is used as a tool by the Supreme Court to ensure that the ball is always in its court. That whatever the Constitutional Amendment Act may be, the amendment, the interpretation would be as per the Supreme Court through the basic structure doctrine as a tool. So there are certain limitations and restrictions and certain issues with respect to the basic structure doctrine, especially when it comes to its interpretation. And as said, the manner in which the judgment was given by the majority of 7 judges and the majority note as signed by them, it also lacked certain clarities. And yes, maybe I forgot this. The Kesavananda Bharati judgment verdict had 11 authors. Generally, a judgment has one or two authors, or maybe three authors, one given by the majority side and the one written for the dissent side. The Kesavananda Bharati verdict had 11 authors, which means out of 13 judges, 11 judges gave their different perspectives. It's just the doctrine was propounded on the basis of one majority note as signed by those 7 judges. So still there are many such things which are, undefined in terms of the doctrine.
That's really a very huge case that we should be saying, like so many inputs given by both the sides, like in towards the pro as well as the cons. And thank you for such insights, sir. So there are a few questions from the audiences. So can we take them?
Of course.
There's a question that says that can it be said that the basic structure doctrine was an outcome of the doctrine of harmonious construction while interpreting the Constitution of India instead of judicial invocation? Judicial innovation.
Judicial innovation. Okay. See, when we look into the doctrine of harmonious construction, it is utilized with respect to, legislative interpretations mostly. And of course, we can say that there are certain these particular backgrounds may become or may be considered as guiding principles for the Supreme Court to make its mind, the judges to make their mind for coming into, a particular situation, or to end a never-ending ongoing issue or debate. Because see, we saw how once we had Golaknath and then another 24th Amendment Act, we had Kesavananda Bharati, and then there were various attempts to undo what the Supreme Court said in the basic structure doctrine or this particular case. But the Supreme Court, the judges were with a particular mindset. So we can say that to some extent, see, it is certainly a judicial innovation. But how the judges had come to this particular conclusion or this particular, situation of giving this particular verdict or propounding this doctrine, which is an absolute sanction of the parliament or absolute restriction on the parliament's absolute authority. So of course, the previous developments and the doctrines and the verdicts, the decisions given by the court in earlier decisions, previous decisions, and of course, as cited, the doctrine of harmonious construction. But harmonious construction is mostly with respect to the legislative interpretation, and that too invoked and utilized in reference to the center-state dispute. If I'm not wrong, if the person who's asking the question is referring to this particular aspect of harmonious construction. So it is basically the difference between these two, we can say, is harmonious construction mostly utilized for legislative interpretation with respect to center-state relations. Basic structure doctrine is specifically with respect to the constitutional amendment acts.
So there's one more question, that is, if basic structure doctrine gives constitutional supremacy for fundamental rights, then sir, your stand on LGBT community rights?
We cannot say that Kesavananda Bharati gives supremacy to fundamental rights, or the basic structure doctrine gives supremacy to fundamental rights. The basic structure doctrine did not give supremacy to any one particular aspect or anything. It just gave supremacy to basic features, which is a very open aspect to be interpreted by the court. But certainly, yes, because, in fact, in Kesavananda Bharati also, the court said that the parliament can amend the fundamental rights, but cannot violate the basic structure. And in fact, the further debate of whether DPSP is supreme or fundamental right is supreme, and then the balanced approach of the court in the further cases. In all these regard, we can say that the Supreme Court tried to establish one particular aspect in which it has been quite successful, that the basic features, basic aspects should not be amended. Now, if we connect the fundamental right, the aspect of fundamental rights and the LGBT, we can say that, the Supreme Court, when it has recognized the LGBT rights, and one of them being, going on at present, it is more of a question on constitutional values playing a significant role in the fundamental rights and the recognition of the fundamental rights of those which is explicitly specifically mentioned, and for those which is not mentioned further, or maybe a liberal approach of the court earlier stating that no, it has not been recognized, but then revisiting it, all these aspects. So we cannot say that the basic structure doctrine provided supremacy to specific aspect, or but certainly it made sure, it ensured that you can amend the fundamental rights if required, if needed, but with respect to the basic structure. I think so that when the court at present is hearing to the matter of recognizing the same-sex marriage, it is looking into the broader aspect of constitutional values, not only in Indian aspect, in Indian context, but across other jurisdiction as well. So let's wait for the verdict to come out and what relation or impact it has in the overall relation of constitutional values and fundamental rights.
That's really very informative, sir. So I guess there's one more question. How would we interpret the scenario, this basic structure doctrine scenario with respect to today's political, judicial, as well as the current religious sensitization?
When we talk about the relation of the judiciary and politics, to speak constitutionally, the relation between the executive and the judiciary, or to keep together the parliament and executive together and the judiciary on one hand, we have already discussed certain aspects as to what impact the basic structure doctrine has, and it can have, and it is having, on the democracy of India, democratic setup in India. We've seen that despite having full majority, absolute majority in the parliament, despite having a strongest form of government in place, still the constitutional amendment acts can be restricted, can be analyzed by the judiciary, because there's a basic structure doctrine in place. Now it's no more relevant whether the government is strong enough or you have an absolute majority in the parliament to get a law, constitutional amendment act passed or not. Now it's important to make sure that it passes the scanner of the basic structure doctrine, and therefore the doctrine plays a significant role in establishing the relation between the judiciary and the executive. Both of them have to understand, in constitutional, in the norms of constitutional interpretation, we often refer to a principle known as the principle of comity, which means wherein the judiciary looks into the executive and their actions through a constitutional aspect, etc., these kind of things. So basic structure doctrine has played a significant role in establishing this connection, but then also creating certain controversies and issues and the debates. For example, recently we have seen that how the government has been pushing on inclusion of one of the members in the appointment selection, the collegium or that particular group for the selection of judges. But it has already been struck down by the Supreme Court way back in 2015. So these are certain aspects related to it.
That's really very informative, and it's to the relevant to exact today's scenario. So thank you very much, sir. You really made this platform immensely, overwhelmingly very enticing with your presence and time. I'm really very grateful that you have come up and gave us your valuable time. I really hope to get more interactive sessions with you. I'm really very thankful for your evening, sir.
I am also thankful to Law Insider and Nishka, you, to provide this platform. It would have, I can say that I would have failed, or I would have felt, really that something great is missing if we could not have discussed this particular aspect in such a platform. When the well-known doctrine, as said, has stated, the die-hard doctrine, when it completes its golden jubilee, and if we would have not got this opportunity to discuss this, I would have failed as a constitutional law student, rather I would say, in this regard, because maybe on the other side, and discussing and playing the role of faculty, but then a person in relation to constitution will always be a constitutional law student. In fact, we have seen how the Chief Justice of India, the present one, he also often refers himself as one of the student of constitution. So I would say that thank you, Law Insider, and Nishka, you for providing this opportunity for discussion. Thank you very much.
Thank you, sir. I'm very obliged, sir. Thank you once again, sir. So I'll call it off. Thank you so much, sir.